You're listening to the Subrogation Support Network, a podcast from Matthiesen, Wickert Lehrer, America's subrogation law firm, with dissemination of new developments and changes in subrogation law, as well as emerging trends and best practices. Here's your host, Ashton Kirsch.
Hello, everybody. This is Ashton Kirsch, your host of today's podcast with the Subrogation Support Network through Matthiesen, Wickert Lehrer. Today, I am absolutely honored to have my partner in our Florida office, managing partner of the Florida office for Matthiesen, Wickert Lehrer, Elizabeth Hernandez, joining us today. How are you doing, Elizabeth?
I'm doing well, Ashton. How are you?
I'm doing great. Happy to have you, and happy to have you on this third podcast. I think that it's going well. It's a lot of fun being able to talk to interesting people, attorneys, experts, everybody in between, and have this forum. So it's going great. But
well, thank you for having me and finding me interesting.
Of course. So today we're going to be talking about some really interesting and unique legislative changes that have come down the pipeline and really caught the industry and legal practice as well by storm. Elizabeth, why don't you tell us a little bit about these changes?
So it's being known as essentially the Tort Reform Bill. Us practicing Floridian attorneys have heard that this was going to be coming in front of us at some point or another, and did finally happen. It was filed in February of this year. It was definitely fast-tracked, and it was passed and signed by the governor in March on the 23rd. So it's going to be changing a lot of what we know as far as tort or negligence in particular claims, and it's going to have some serious impacts. Attorneys and plaintiffs and carriers alike will have to start getting ready to make adjustments to the new changes, start putting new deadlines in, implementing new practices in order to keep up, and also to not, more importantly, fall back and miss some sort of a deadline. Or if you are an attorney, finding yourself in malpractice, or as a carrier, finding yourself without any relief in which to pursue subrogation and recovery.
Interesting. I mean, what really fascinates me about this is just for the insurance industry as a whole, a lot of carriers, I mean, this is beneficial. It is a beneficial impact in many ways to insurance carriers. But it's unique for us on the subrogation end, because it has truly a very detrimental impact on subrogation claims, given the issues we'll talk about shortly. But, really it's the idea that claims are going to be limited, the cases we can pursue, the damages that can be pursued, and so forth. So, that's kind of an interesting factor when you have something that hits, both the liability side one way and subro a different way, right?
Yes, and it's funny you mention that because if you were reading the news or following along with any of the articles, and whether it was coming from defense firms or the plaintiff side, us, in subrogation, we kind of sit in the middle. So the carriers or the defense side that had more of a voice in this whole passing of this bill, they found it obviously is going to be very beneficial for a carrier on the defense end. It's going to, the idea behind it was to decrease frivolous lawsuits, i.e., they were going after the billboard attorneys, those big plaintiffs firms that, possibly operate on a mill and are just filing anything, whether or not there was an attempt in good faith to resolve pre-suit and or there's sufficient facts in order to move forward with filing the claim. So that was kind of the target or the idea behind it, at least on the forefront. And yes, carriers on the defense side are going to have a much overall, I believe in the long run, it'll be a much better position for them. However, for us in subrogation, because we do run along with the plaintiff side, and or we are the plaintiff on a lot of property claims, even filing directly on behalf of a claimant in a work comp suit, for example. So this is going to have some pretty detrimental impacts on us on the subrogation side of the carriers end.
Absolutely. And, there's definitely not a lack of billboard plaintiffs firms down there in Florida. If you've ever rode or driven down the highway, everywhere you look, you have a sign. I won't mention any of the names in this podcast, but I mean, coupled with the same name repeated over and over again. Either way, they are everywhere. And that's the subrogations. I mean, it's interesting because I am truthfully, as a subro attorney, we're plaintiffs attorneys. Sadly, I don't think I'll ever have one of those big billboards, even though, I'd love to have one. Imagine that, Elizabeth. Do you think Ashton Kirsch, big picture of my face on the side of the highway, send us your subro work? I don't think that's going to work.
Yeah, I try not to.
So, all right, let's go into the meat of this. So can you give me a brief recap or some sort of summary of the major changes that have been brought about by this recent legislation?
Sure. And there are going to be a lot of changes, too many for us to be able to even cover in this podcast. So I'm just going to we're going to cover the major ones that are going to have the most significant impact on subrogation, especially on the front side of this bill. Obviously, over time, we may start to see other types of impacts, negative impacts. Over time, we may end up seeing that there is some positive, but for right now, we're just going to focus on 4 of the major impacts that we need to just be aware of as subrogation professionals. First one being the pure comparative change from what Florida used to have. Statute of limitations is probably the biggest one to be concerned with for both the subrogation professionals and attorneys alike. There's also going to be new processing for calculating medical damages. It used to be amount paid, not the amount billed. I'm sorry, it's the amount paid now, not the amount billed, which is going to be significant for us on the subrogation end for workers' comp or MedPay type claims, where those used to be included in jury awards, what was billed, not what was paid, which is helpful on our end because then it leads to a bigger recovery. We'll get into it more later on in this podcast regarding how that's going to impact subrogation claims when it comes to the Manfrotto formula we use here in Florida. And also another one to be looking out for have been modified to almost the extent that the plaintiff's firm is arguing removed any liability on a property owner for negligent securing. So we'll get into all of those a little bit more as we go on.
Perfect. So I've heard some interesting rumors about this. One of the rumors that I've heard was that over 100,000 new lawsuits were filed like the day of or immediately after this. And obviously that's all, I've heard that in the news, but, is that true? I mean, what have you heard about this? And what are the impacts that you're seeing on Florida courts?
So yes, it is true that there were a significant, I don't know the exact number, I'm not even sure that it has or even was calculated, somewhere in the area of 100,000 files, possibly more likely than not, plus were filed within the week leading up to the governor signing this bill, keeping in mind that this bill was fast-tracked. So there was not a whole lot of time for plaintiffs in particular to get prepared and ready for what the final impact would be. Normally bills will hang out for a while and change over time. So here, when it was apparent that this bill as it stood was going to be signed by the governor, there was about a week and a half period that gave plaintiffs' attorneys a chance to go ahead and get whatever files they had filed, because a lot of these changes, the major ones that we're going to be discussing today, were effective immediately upon it being signed by the governor. So regardless of whether or not any particular incident happened on the exact same day preceding this bill, if it was not filed with the courts by the time this bill was signed, then these new major changes, all of which we're arguing are going to have negative impacts, would now apply to your case where they wouldn't had you filed 24 hours before. So yes, there was a lot of running to the courthouse. You don't have to do that anymore. It's on e-filing. But there was a lot of filing of cases. It's going to have a detrimental impact on the court systems. I think ultimately both the defense and the plaintiff side is really going to start to feel the burn because of this. We were just coming out of COVID, and because of the COVID backlog, it was mandated in the state of Florida that all new filings had what we call here CMOs, their case management orders. What they do is they create immediate deadlines. It's to fast track cases. Where it used to be you could file a case and it could be in litigation for years and years and years, just depending on the circumstances or how it is you practice. Now, cases must be resolved to trial within 12 to 18 months based on these case management orders. Now, this is nothing new in Florida. We've had CMOs for about 2 years now, if not more. Prior to this bill, there were a lot of judges and a lot of opposing counsels, both on the plaintiff and the defense, who were agreeable to extensions on these deadlines. However, already I'm starting to see that that is no longer the case, and especially when it comes to the judge. Now anymore, simply filing a motion for an extension of time on these CMO, case management order deadlines, are immediately being denied even before a hearing can be set, even if they are stipulated to. Both parties agree to have the extension. Judges are so overwhelmed right now with cases. It's now then being taken back and on to the parties of the case. So that's going to have a real big impact because it takes time to investigate and to go through the litigation process, finding people for depositions, getting them set up for depositions, the mediations, so on and so forth. So this is really, 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 really important to keep in mind as we're going through these major changes, because the court system's reaction to this influx of files is definitely going to be felt by everybody.
That's crazy. I mean, I know Elizabeth recently did a webinar on this topic, and we had a ton of questions on this. And carriers are scrambling. I mean, it sounds like the courts are scrambling. Frankly, it sounded like the legislature also scrambled to get this passed. But I mean, it's kind of the Wild West out there right now, or down there right now, in that the judges are pushing these things forward, and there's going to be a crazy backlog. I mean, it's kind of wild to hear the true quantity of cases that have been filed. And I'm really interested to see what happens over the next few months as we see how just truly the judicial system in general handles this.
It's going to be interesting. There are a lot of these billboard attorney firms that have also gone out publicly on the record and have simply stated, you know what, insurance carriers on the defense side, you wanted this tort reform, now you have it, but we're not going to be extending any more professional courtesies. There will be no extension on discovery deadlines, expert deadlines, depots, nothing. So now you've met your match. So not only are the defense carriers going to have to worry about the courts pushing things forward very quickly, the plaintiff's attorneys have said, you know what, we're going to make things even more difficult for you.
Interesting. So now let's go into some of those specific changes, because we've talked about the context more broadly. But my understanding is one of the major changes is that the statute of limitations has been impacted. I think specifically it's that the statute of limitations, the SOL on these claims has changed from, is it 4 to 2 years? Is that right? And how do you expect this to impact both subrogation claims and just general litigated claims going forward?
So yes, the statute of limitations for negligence actions was previously 4 years. Now it is 2 years. And keeping in mind that is for negligence actions. There are a lot of other type of tort actions that the statute of limitation has not been changed. So it's important that we just keep in mind that these are going to be applied specifically for actions based on negligence. A 2-year statute of limitations, well, Florida, I don't believe even had a cause of action that was at least one that was filed often outside possibly contribution that had anything less than 4 years. So it's going to definitely be an adjustment for both sides, because as the plaintiff bringing the case, 4 years was a substantial amount of time in order to get your investigation done, attempt some pre-suit, possibly joint discovery, possibly if needed, do pre-suit settlement conferences, get all of your ducks in a row to be sure that moving forward with litigation, bearing the cost and the time, was the right decision. Now, this has been decreased by 50%, which is also important to remember too, that the plaintiff's attorney don't have any control when their clients bring them the cases. So if they have a case that their client, for one reason or another, got treatment, but didn't decide to pursue suit, waited 18 months to finally retain an attorney, now they're looking at 6 months before they have to file. That's not enough time to really even, although good faith could be there, engage in settlement negotiations. You have to just get ready to go ahead and file. And again, that reason there, the limitation being decreased to 2 years, is also going to create an additional wave of cases being filed because the time frame has shortened. There's not enough time to get whatever it was that we need to get done before we file suit. So the options now is just going to be, well, now we have to file suit and we'll go through the litigation process, again, increasing the court's case count
Yeah, so you're going to see a ton of these cases. I mean, just thinking about it, I think about the context and the applicability to like work comp subrogation cases, where somebody maybe hasn't reached, the claimant hasn't reached MMI, or they're still treating at this point when suit has to be filed, which does happen all the time. But it could still be in the early stages of trying to figure out exactly how treatment's going to play out, what those total benefits are going to be. And, that just leads me to think, I mean, have you thought about, how this is going to impact our various work comp carriers and those clients who have subrogation claims?
Yes, and I feel that the work comp claims or those types of subrogation claims are going to feel the negative impacts more than probably other areas because of the different changes. Not all of them we're going to discuss because we would be here all day, but things like, for example, the new process for calculating medicals that also touches on letters of protection. We can get into that a little bit more when we start talking about the workers' comp portion and the impact that it's going to have. So yeah, it is going to be very important for workers' compensation carriers to be very prudent and staying on top of their claims. One, they're going to be filed much more quickly in courts than they were previously. Two, the statutes, the collateral source, for example, that require notice to the plaintiff have not changed. So where before you would get what's called a 30-day collateral source letter from a plaintiff's attorney, you had 30 days to provide them with your lien and your intent to pursue your lien. Should you not, the statute reads that you waive your right to your lien. Those they're going to be seeing, obviously, with the 100,000 cases that have filed, I'm going to conservatively say or imagine that at least 30%, possibly much more, are stemming from some sort of workers' compensation claim. So those are going to be flooding into the comp carriers like crazy, those letters that they need to be on notice of, in addition to new claimant files being filed much sooner and much more quickly than they were in the past. And because the plaintiff's firms already have admitted that they are providing no deference to insurance carriers, I feel that mood is also going to then spill into the comp side simply because we are a carrier. They will not be providing us any sort of leverage. You miss that 30 days, you're done. So those are just the things that we really need to be cognizant of as work comp subrogation professionals.
Great. So another similarly important change and something else that I feel like we definitely need to touch on is the general change of how this bill impacts the comparative fault regime and allocation. It's my understanding that Florida was previously a pure comparative state where obviously even if you were 20%, you had an injured party who was 20%, well, let's say that they were 80% at fault. Well, then they could still recover the 20% against the tortfeasor. Now it's a 51% modified comparative fault state. How do you think this is going to impact claims going forward?
This is going to have, assuming that we're talking about cases that have been filed after claims that come up after the effectiveness of this bill. Claims before, where, again, like you said, where our claimant or even if it's a property claim, our driver was found to be 80% at fault. Well, we still at least could recover something. There was a chance of something being able to be put back into the pockets of the carrier. Now, well, that something has now decreased by 50%. So those claims where we could actually argue some sort of recovery, even if we were slightly or majority at fault, that is no longer going to be a possibility. So those claims will have to be closed out much more quickly, and those claims will not see any recovery at all.
Right. So there's a huge chunk of cases now that previously this type of claim would have been at least partially recoverable on the subrogation end in Florida. And now it's just gone, right? Now there's just simply on those cases where our driver, our individual who we are, subrogated into their shoes. Now there's just simply no right to recover there. So that case isn't going to be pursued by a plaintiff's attorney. We can't pursue the property damage as a, subrogation counsel. It's just basically, frankly, it goes back to the majority rule. I think it's my understanding is that I believe 34 states follow some sort of modified comparative fault rule with 10 states with a 50% bar and 24 states, I believe, at the 10 states at 50% and 24 states at the 51% bar. I believe that's my recollection. And now it's just going to be similar to to those states, right?
Yes, it is.
Interesting. And I guess the one thing that is important to note from what you said is that this is for all filings that have occurred after this bill has passed. So even if you filed the day afterwards, you're no longer pure comparative. You are now modified comparative at that 51% bar.
That is correct. So although you could have had the exact same set of facts, the exact same day, two separate accidents, one attorney filed before the effectiveness of this bill, the other attorney filed 15 minutes too late the day after, two different sets and standards of negligence will be placed on those cases. That's why it was so important for these plaintiffs' attorneys, regardless of whether or not they had an opportunity to investigate the claim, the allegations, so on and so forth. They needed to just go ahead and file before this bill became effective, because otherwise they were going to lose out on at least the ability to collect something.
Right, because there's going to be a lot of those claims at the periphery where we believe, yes, the tortfeasor is primarily at fault, but maybe let's think of the rear end collision, right? Our vehicle's rear-ended. Well, maybe the other side's then alleging that we slammed on our brakes, right? Under the pure comparative approach, well, we have some right to recovery. There's going to be some dollar value there for settlement purposes. For how this is approached, there's some value, but that case has then ultimately really lost value under the new regime, because now we have to prove 51%. So, primary responsibility. So it's going to be, I'm fascinated to see how that plays out and what you see going forward. Now, next thing I want to discuss is, it's my understanding another major change, and there's lots of changes here, obviously, is the change to provable medical benefits. Significantly, this new law, as I understand it, it limits the evidence that's going to be admissible to prove the amount of damages that the plaintiff can recover for both past and future medical treatment. Can you walk me through this change and how you really expect this shift to impact future litigation in the state of Florida?
Sure, and we touched on it a little bit earlier. Before, and we're presuming that this is being presented in front of a jury, it's the easiest way to explain kind of the impacts. Jury sees the amount billed, so they're given all the medical bills, which calculated up gives you a total. They go back and they include that in whatever their verdict is, and let's say it's for the plaintiff. So they get whatever was billed, all that was billed. But we know that behind the scenes, just because it was billed doesn't mean that that was the actual amount paid. There are often reductions. Sometimes there are people waive bills. Didn't matter. They were still able to recover the amount billed, which led to significantly higher plaintiff's verdicts and awards. Now that is not the case anymore. They will be provided what was actually paid, which is going to significantly reduce the amounts that are going to be awarded. Now, obviously that was for the scenario in front of a jury. That doesn't negate the fact, though, that now carriers know this. So when pre-trial negotiations, even pre-suit negotiations are being had, that is going to be something that they're going to use as a basis of, well, no. It used to be valued or was potentially valued at that the Tort Reform Bill. But as you know, if we took this in front of a jury, that value is not going to be the same any longer. So valuations, and this again goes back at the workers' comp, the impact that they're going to feel is significantly going to change moving forward, because those numbers are going to be probably, I would say conservatively in most cases, cut in half.
Right. And we could do a whole presentation on Florida Comp, which we actually do have a full presentation on Florida Comp and how the Manfredo formula applies and so forth, which is really interesting. But ultimately, one of the primary factors, well, there's two primary factors that are impacted here. One is going to be obviously the amount of money that's received. It's going to be more limited, assumptively, given the fact that provable medicals are going to be smaller. It's not, it's amounts paid, not amounts billed, pretty much. But the other impact is I'm kind of fascinated to see how it plays out in the other major tenet of Manfredo calculations, which is the actual value of the case. Because typically, that's one of the big arguments in these things. On the work comp side, we're arguing, hey, this case is actually worth, whatever we're saying, some multiple of medical benefits. And plaintiff's attorney comes up with some other number, which, I usually think is crazy, but saying the case is worth this much. Now, it's going to be fascinating to hear how that argument and that correspondence goes now that they might still be arguing, well, look, this is what a case was worth, the last time this was tried. Well, we're coming back and saying, yeah, well, this is a new bill and take a look at this. Obviously, sure would have been worth $250 a few years ago. But today, under the current law, your case is actually worth this multiplier based on these paid medicals, not billed medicals. I mean, it's going to be interesting to see that. I mean, do you have any thoughts there, Elizabeth?
I do. And I'm often involved in these valuation Manfredo arguments. And obviously the plaintiff's attorney is always bringing up, oh, well, look at this verdict on this case with similar facts and circumstances. And I also have this one to support. Great. Yes. We can see through the allegations or whatever the discovery, and obviously the award is filed. So sure. The problem is what isn't going to be there is what was actually paid, what is in those previous cases or verdicts that they're using for valuation purposes in our argument of Manfredo doesn't include what was actually paid. So it's going to make it a very difficult and interesting argument moving forward, because unless, of course, that was their file that they were able to produce, this is what was actually paid, we'll never know. So I'm going to be very interested to see how these negotiation arguments and ultimately hearings in front of a judge play out.
So this is probably another reason why, and I always recommend clients think very carefully. And I mean, it may sound self-serving. It's not. It's just the right approach. Why legal counsel, it's always necessary to consult with legal counsel on cases in Florida with comp. I mean, because a lot of times I'll talk to carriers, they'll say, hey, you just send a notice of lien, we're good, and we'll just, argue in the future. But this is going to get more complex because we're going to have a lot of back and forth for at least a few years, I would imagine, where plaintiffs' attorneys are relying on past valuations, and we're coming forward saying, hey, hold your horses. We're not talking past valuations. We're talking about the current legal system, the current regime. And after these changes, your case is worth far less than it was previously.
Absolutely. Absolutely. But it's not to say, though, that the property ones, it isn't as important to get them to counsel. Obviously, we are still dealing with the statute of limitations has changed, but there's also a liability portion. And being able to have an attorney look at it sooner than later, obviously, because we're dealing with a shorter time frame. And we're also dealing with a liability that has now cut some of our claims, the ability to recover at all, or at least in half. The sooner we get them to counsel, the better. But yes, on the workers' comp, it's always best because there are so many other variables to take into consideration, not only Chapter 44, which requires it to file a notice of intent to recover your lien in the plaintiff's attorney's case. And there's case law that says that if you fail to file it, then you waive your lien. There's also the collateral source letter that I mentioned earlier that are often sent out by plaintiffs' attorneys to these carriers with that 30-day deadline. And the statute is clear on its face that if you do not respond within 30 days, you waive your right to recovery. And because these things are moving so much more quickly, not only with the 100,000 that were filed, but the ones that are going to be filed much sooner moving forward, it is so very important to get counsel involved. My fear for our comp carriers out there is that the comp department of any given carrier is given or sent out these 30-day demand letters. And unfortunately, maybe it sits in a pile or they're just not completely informed or aware. And that 30 days passes. And now, sure, absolutely, we'll still move forward and try to recover. Should there be a recovery on the plaintiff's end? But we're definitely going to have a really big hurdle to overcome on why we didn't comply with the statute. There's no case law yet that determines whether or not it's strict compliance. I don't want to be in that position. So it's better just to get the comp claims moving forward to counsel as soon as possible. They could weed through all those issues, put plaintiffs' attorneys on notice of representation of our intent to pursue our lien. And additionally, being from Florida and familiar with the court systems, we have ways in which we can figure out ourselves if, in fact, the plaintiff moved forward and filed. We don't need to wait around for an attorney to put us on notice.
Absolutely. And so the work comp statute, to my understanding, it has not changed. So all the same rules still apply. Another interesting factor would be under Florida law, the carrier gets the second year where they have the right to actually file on their own. And it's going to be interesting to see how that's impacted, because there's going to need to be a lot, action is going to be a lot quicker. And you're going to have situations where we're sitting here thinking, well, we can't just wait. A lot of times I'll have clients where we say, hey, we can file now, it's second year. And they say, no, you know what, let's just hold off. I'm sure the plaintiff's attorney is going to file suit in the third or fourth year. But now it's going to be second year. We have the right to file. And then after that, it's done. So I think there's going to be a lot, probably, and I'd want your insight on this. Are there going to be a lot more situations where us as subrogation attorneys on behalf of workers' compensation carriers are actually filing independent actions more often?
I definitely anticipate that that's going to be the result of this bill. Absolutely. We won't have time to sit around and wait. And unfortunately, because the statute of limitations is 2 years, we would be within the last year of our right to file. We wouldn't have an option because we can't hang out and wait. We would need to just, again, we run very similar with the plaintiff side. We would need to just go ahead and get it filed in order to preserve, and then hope, that we can get everything put together through litigation, keeping in mind that these case management order deadlines are not going anywhere. They're becoming more, strict on complying with them. So again, that's the other challenge is that we're going to have to face as we move through this process with this new bill.
All right. And finally, there's really one additional change that I did want to make sure we touch on during this session. And that's it's my understanding that the law also modifies premises liability rules. I believe that it requires a jury to consider the fault of criminal negligence in security cases involving criminal acts by third parties. My reading of it is that it creates a presumption against liability for negligent security claims against owners and operators of multifamily residential property. And yes, I'm sure you can imagine, I did just read that off of my notes. Walk me through this a little bit. It seems like it's a unique change that's, obviously not applicable to all claims, but will be very, very applicable to those claims involving premises liability and, negligent security in specific.
Yes, and this is a very big issue for the plaintiff side as well, because this was not the case pre the signing of this bill. And this does definitely change it shifts the responsibility almost. Where it used to be that if a property owner knew that there were crimes happening near or on the property or within the area, that they were responsible for, maintaining the requisite security, whatever it may be. Or if they did maintain the requisite security and then at some point or another failed to, for whatever reason, these were all bases in which one could move forward with a negligent security act. The way that it reads now, it's almost putting the burden on the plaintiff, because it is providing them that presumption against liability. And obviously this particular change within the bill is going to close to eliminate a lot of those premises liability cases that were being filed before, that were being recovered on and awarded previous to the bill.
Thanks, Elizabeth. Now, during your webinar that you had presented, I recall there being a number of questions that were sent to you. And one of the biggest questions that you told me about was follow-up and folks asking, what's the effective date of the legislative changes? And I know that you've mentioned this a few times, but I do want to kind of pound that into the head of the listeners. Can you confirm kind of how the effective date is applied and how it differs amongst the different changes?
Yes. And I did get a lot of questions because it is, I would argue, the most important change, at least to be aware of and on top of. And it applies differently to the different changes. So, most importantly, the statute of limitations. The statute of limitations post March 24th is 2 years. Any incident prior to that would still maintain the 4 years of statute of limitations. So the language of the new bill reads that any incident accruing after the date of effectiveness, which is March 24th, will now have a statute of limitations of 2 years. So if I rear-ended you on the 24th of March, you have 4 years. If I rear-ended you at 12:01 on the 25th, you have now 2. So that's important to keep in mind. Now, when it comes to the negligence standard and the medical damages that we discussed before, what was billed as opposed to now what was paid, and addition to the negligent security changes and most all of the other changes within the bill, focuses on the filing date. So if like I said before, two of the same incidences happen on April 1st of 2022, if attorney A was able to file B on or before March 24th, then they get to retain and use the old standard for negligence. They get to show billed amounts. The negligent security is the old standard. So that is very important to keep in mind. That also applies to the medical damages, so on and so forth. So the effectiveness for those other changes happens after signing on March 25th, with the exception of the statute of limitations.
All right. And, the final thing that just was kind of interesting is when I was reading about this, there was some reference to some changes to the fee shifting provisions and changes that were done in 2022 in Florida, and that it's kind of expanded that. Have you done any review on how fee shifting and how that's going to apply? I think that's an interesting concept.
It is, my opinion, to be honest with you. I think that's more going to impact the defense carrier side and the actual plaintiffs, PI side of things. They were using, this is going at the bad faith and should we have a proposal for settlement, should those be popped in and reward of attorney's fees is given, whether it be bad faith through that litigation or through a proposal for settlement. That is when it's going to actually, when those impacts will be felt. I don't think that we're really going to see that on our end over here in subrogation. So I don't think that's something that we should get down the weeds or the rabbit hole into. That is specifically going at bad faith actions. The defense side was arguing that there would be an affidavit signed by an attorney saying, yeah, these are reasonable attorney's fees. And it was $800 an hour. That's what that is going to attempt to resolve or impact, that it would bring it down to more reasonable fees. And the method in which to show that has now changed. But again, on the subrogation end, I don't foresee that necessarily being something to be concerned with as of yet.
Okay. I mean, these are huge changes, right? This isn't, hey, there's a slight change to, one element of the claim. I mean, this is a true revamp and recreation of how claims are going to be litigated in Florida. Now, do you have any, you briefly touched upon recommendations, but do you have any other recommendations on, what insurance carriers should be doing now, or what subrogation departments need to be doing going forward with these new legislative changes?
Yes, I think it's very important to keep in mind that the timeframes have changed. I think that's probably the most important, or the number one thing to really start either implementing or reviewing with the departments, understanding what changes there are in these timelines. For example, the statute of limitations, but how also that is going to affect, again, as we discussed with comp, it's going to impact statutes that were not impacted or modified by this bill, but that still have application. Example 440 and the collateral source deadline. Additionally, because things have changed significantly when it even comes to negligence in Florida, I think it's going to be important to get these files sooner than later to an attorney. As we go through these new changes, the early days are going to really start to show us how courts are going to be ruling on these issues. There are still a lot of issues within this bill that have yet to be truly, I guess, flushed out. These issues are going to have to go through the litigation system and at some point or another be reviewed by a judge and an order be entered, and that would be, what we would know is how we would proceed forward. So keeping up with all the changes, all the different case law that comes out, knowing what the rulings were, knowing if back pocket one that would work in your case, having that type of knowledge and insight is going to be really important transitioning through all these changes. And that's why it is just very important to try to get it to counsel as soon as possible. Obviously, we need to weigh the benefits of the loss to the cost of litigation and pursuing investigation and pursuing subrogation. So once that determination has been made, yes, this is one that's worth moving forward with on subrogation. It's probably going to be in your best interest. I would say it is in the best interest of recovery to get it to counsel as soon as possible.
Well, it sounds like there's going to be a lot of questions as we go forward, as precedent is created, as courts interpret these different changes. Now, I'd imagine that plenty of our listeners are going to have questions, right? Questions for counsel. Now, if anyone wants to reach you, Elizabeth, what's the best way to get a hold of you? And are you willing to take questions from clients on these issues?
Well, Ashton, MWL is always willing to take questions. As a matter of fact, Ashton, did you know that our website has a little ask a question button that anybody, clients and non-clients alike, can ask us questions about any area of subrogation? This one included. Yes, they can obviously use our website to ask a question. It's Florida related. It's going to come to me. So if that's easiest for them, that works. My email address is E as in Elizabeth, my last name, Hernandez, HERNANDEZ, at MWL-law.com. Or they can just simply give me a call, 800-637-9176. We are always happy to answer questions firm-wide, whether it be on this bill or anything subrogation related, legal related even. If we don't have an answer, we will obviously try to get you in an area of outside subrogation to somebody that does, but definitely any subrogation questions at all, ever, please come to us. And if you have any specific questions regarding this bill and the changes, the potential impacts, I'm happy to follow up with you. Obviously, I don't have a crystal ball. I don't exactly know how this is all going to play out in practice over time, but I'm happy to just discuss even, the potential impacts theoretically anytime.
Excellent. Well, Elizabeth, I think we covered most of this. Is there anything else that you want to add?
No, I think we have covered the major points of this, but I'm certain that there are going to be a lot of questions. So again, feel free to reach out.
Absolutely. I feel like we're going to have another conversation. We're going to have to invite you back on the podcast, maybe in 6 months or a year, to kind of have another talk to just discuss, where things have gone, how things have developed, because truly, with these, paradigm shifting changes, it's going to be interesting to see how things go. So, well, I thank you, Elizabeth. It's been a pleasure. Thank you, everybody, for listening today. This is Ashton Kirsch signing off with the Subrogation Support Network. Look forward to hearing from you at our next podcast coming up in just 2 short weeks. Talk to you soon.